Hello. In today's video, we are going to discuss about the topic capacity. Now, what do we mean by capacity? And what are the types of things which we're going to study in this video? We are going to have a look at it. So, capacity refers to the ability of a person to sue or be sued. So, capacity in terms of whether you can sue for a wrong or whether you can be sued in the court for wrong, right? So whether you can file a case against a wrong and whether you can against you a case can be filed. Now this in respect of our discussion means whether you can be sued for a tort or whether somebody else can sue you for tort. This is what is meant by capacity. So here with respect to capacity, we are discussing the capacity to sue or be sued. Now in general, as a matter of principle, every person has a capacity to sue or be sued. This capacity is available with everybody. However, there may be certain variations to this rule or certain exceptions in certain circumstances. So in the present discussion, we are going to see the capacity to sue or be sued for torts with respect to a category of persons. Now, why only a specific category of persons? Because these are persons which are very essentials to understand whether they can sue or be sued. Correct? Now, understand in general, everybody has a capacity to sue or be sued. Now, what are the different categories of persons we are going to study? We are going to study about act of the state. Now, act of the state with respect to other states. Correct? Now, corporations or companies, capacity to sue of minors, of independent and joint tortfeasors, and sometimes called composite tortfeasors. We're going to understand first what are independent and joint tortfeasors, what is their capacity, what is their liability, all this we're going to see. Husband and wife, this position is fairly settled now, but we're going to see what was the position earlier. Persons having parental or quasi-parental authority over somebody else, and persons having judicial and executive authority. So in general, we're going to see whether these persons have the capacity to sue or be sued. Now the first is an act of state. So here the principle is that an act done in exercise of sovereign power in relation to another state or subjects of another state is an act of the state and cannot be questioned by municipal courts. Now always remember, here we are talking of an act of the state. State refers to a country as a whole, sovereign power of the country, act of the country as a whole, as opposed to other countries or subject of other countries, not with respect to the state of Madhya Pradesh or the state of Uttar Pradesh. It is a capacity as a whole, and it is with respect to what? Another country. Correct? And with respect to the subjects of that country, not internally. Correct? Now, what is essential is the act must be done by the representative of a state. Now, it is with respect to the representative of a state. The act should be injurious to some other state or its subjects. So it is with respect to some other state or subjects, and the act may either previously be sanctioned or subsequently ratified by the state. Now I explain you the difference between sanctioned and ratified. Sanctioned is when you get a prior approval and you do an act. So previously sanctioned, a prior approval is called a sanction. And if you have already done an act and then you take permission for it or then you take approval for it, it is called a ratification. So a ratification is after an act is done and a sanction is before an act is done. So a previous sanction or a subsequent ratification by the state. Always remember, here we are talking of the capacity to sue the country as a whole. Municipal courts do not have the power to undertake such actions. So the capacity to sue or be sued here with respect to the country as a whole. In the case of state of Saurashtra, now the state of Gujarat versus Memon Haji Ismail, Justice Hidayatullah had stated one thing. An act of state is an exercise of power against an alien and neither intending nor purporting to be legally founded. A defense of this kind does not seek to justify the action with reference to the law, but questions the very jurisdiction of courts to pronounce the legality or justice of the action. So basically it says it is with respect to another state. They do not seek to justify the question in whether they have jurisdiction or not, or do something like this. Now always and always remember, an act of state cannot be with respect to sovereign and his own subjects. So you cannot do a tort or a wrong and claim defense with your own subjects. So that's why I said one country with another country or another country's people. India, if somebody does something wrong in India, your citizens can question that. We all know we can sue the state. We can sue the state. We will also study about the liability of state, the liability, vicarious liability principles of state. So liability does exist. You can sue the state. You can sue the Union of India. But what capacity are we talking of here is with respect to the country as a whole. That is a contention of international law and international courts of justice. In municipal courts, do not look into that. The next category is corporations or corporates or companies as we see them. Now, first, in order to understand the principle of liability when it comes to corporations or corporates, let's understand the basic principle of what corporates are and what corporations are. Correct? Now, when you understand the basic principle, let's look into it like this. A corporate or a company is an artificial entity. It is not a natural person. It only becomes a person because of the legality that law gives it. So, what do I mean to say? It is a legal fiction. Companies Act 2013 has created a category of companies. Only if you register under Companies Act 2013 will you be categorized as a company. So a company is a different entity and members are different. Separate legal entity. Company in itself is a person. So it says a corporation is an artificial person. Yes, it is an artificial person and it is distinct from its members. It is different from the members as a whole. A company is not equal to its members. A company is in itself a person. That personhood is given, that company is recognized as a person under the Companies Act 2013. Okay, now being an artificial person, it always acts through its agents and servants, and as such, its liability is always vicarious for the acts done by other persons. So a company is an entity, but because it is a legal fiction or a separate legal entity, you need somebody to exercise the company's will. So when you need somebody to exercise the company's will, that other person may be an employee, a director, a key managerial person, somebody like that. And the company's liability is always vicarious. Why? Because vicarious means coming through somebody else, because somebody else is doing that act for you. That other person is acting for you. Okay? So a company, if it has to sign a check, the company will not sign a check. The directors of the company will sign a check. If it has to enter into a contract, it will be by the directors in the name of the company. So therefore, the liability is always vicarious. It was at one time doubtful whether corporation could be sued for torts like malicious prosecution or deceit where a wrongful intention was necessary. Now, why was this a question? Because for torts which did not require intention, it was clear that because a company is a separate legal entity, no brain, so a company can be sued. But where in cases the company requires a brain, a company does not have its own brain, so who should be sued? Now, it has now been held that even though the corporation may not have the requisite mental element for a tort requiring malice, its agents are capable of having the same. And therefore, if the act is done within the course of their employment, a corporation is liable for the acts like an ordinary employer. So, whenever a wrong or a tort is committed by a company, you are liable for it. A company is liable. Vicarious liability attracts. The criminal law also, when you study it, you will see the concept of alter ego being developed. That there is an alter ego, somebody else exercises the power. So obviously a corporation will be liable. So a corporation could therefore be held liable not only for trespass, libel, trover, conversion, or negligence, but also for malicious prosecution or fraudulent misrepresentation. So what do we mean here? That not only ordinary torts which did not require mental element, but also for those torts which required a mental element, you can be held liable. That is, a company can be held liable. It says there is no doubt that a corporation is always liable if the scope of authority or employment of its agents or servants acting on its behalf was within the power or intra vires the corporation. Now, I'll explain you the difference between intra vires and ultra vires. Now, I've already told you a corporation is an entity created by law. So, when a law creates an entity, the corporation also has to see, or the law also has to see what powers to give it and what powers are not there. So when a corporation or a company is made, there are certain objects which are there, and those objects are the authorized objects. A company cannot do whatever it wishes each and every day. It has a limitation in power. So those approved objects are called the objects. Anything done inside those objects are called intra vires. Anything beyond that is ultra vires. Correct? So the company can always be held liable for anything done within the powers. But this law also evolved to say a corporation will not escape the liability in torts merely because the act done is ultra vires of the corporation. Therefore, it can be made liable for both intra vires and ultra vires torts. So basically, it says it will be liable for acts which are inside its power and also beyond its power. Intra vires is something that is within the power of the company, the power given either by the objects memorandums or by the law itself. Now, a corporation is an artificial person. Next, Campbell versus Paddington Corporation. This is a case which will tell you how a corporation can be held liable. The defendants in this case, the Paddington Corporation, a metropolitan borough, decided to erect a stand on the highway adjacent to Campbell's house. So, a corporation decided to erect a stand adjacent to somebody's house. The stand was intended for the use of council members and friends to view the procession. Now, there are processions which go on. To see that procession, you wanted to erect a stand. Consequently, this construction obstructed the view from Campbell's house, leading to cancellation of bookings by prospective lessees who intended to watch the procession from her property. Now, what happened? She had some procession which had to go from the property, but the corporation, built in her. This corporation is also a separate legal entity. So, corporation does not only mean a company, it can be a body corporate, it can be a society, anything of that sort. So, you could not see it. Feeling aggrieved at the potential loss of revenue, Campbell filed a lawsuit against Paddington Corporation seeking recovery of damage due to loss incurred by the erection of the stand. The court found that the stand constituted a nuisance. Nuisance in legal term is an act that unlawfully interferes with the use or enjoyment of somebody's property. So if somebody is using a property and you obstruct it, this can be a nuisance. By obstructing the view from Campbell's house, the stand interfered with the ability to rent out seats, which was legitimate and foreseeable use of her property during the procession. So you had the right to use your property and somebody erected it in front of you, erected a stand in front of your house. That is illegally doing it. That is not lawfully doing it, and so the corporation was held liable for nuisance. Now, the third category of people which we are going to see is a minor. Now, what do you understand here by a minor? A minor is a person not of ripe age, not an adult. Correct? A minor has a right, like an adult, to sue, with the only procedural difference that he cannot sue himself but bring an action through a next friend. That is, you need a guardian to bring an action for a tort. So you can sue but through somebody else. Minority is no defense under law of torts, and a minor is also liable in the same manner and to the same extent as an adult for the tort committed by him. So you can sue one, you can sue through a guardian or a next friend, and you can be sued. The law of tort does not make any distinction on the basis of age. Thus, a child of 7 years can also be sued for trespass for a person of full age. So, in torts, a minor has a right to sue through somebody else and the liability to be sued as well. However, if the tort is such as requires a special mental element such as deceit, malicious prosecution or conspiracy, the child cannot be held liable for the same unless sufficient maturity for committing the tort can be proved in his case. So in case of torts requiring mental element, you cannot sue until you prove that you had the requisite mental capacity or maturity to commit the crime. So in cases of minors, you can be sued, you can sue through some other person. With respect to ordinary torts, you can be sued. With respect to torts requiring mental element, what can you do? It has to be proved that you had the sufficient mental maturity for committing the tort. Now, in minors, as a general rule, a parent or a guardian cannot be made liable for the tort of a child. So a parent or a guardian is not liable. But there are two exceptions. So in a tort, the person, the child himself is liable. But there are two exceptions. Now, whether the child is the father's servant or agent, or the father is vicariously liable. You can also read mother here. So the father or the mother's agent or servant. It may be noted here that in such cases, the father is liable for the son's tort, not as his father, but in the capacity of an employer or principal. So, for example, somebody employs their child, a minor child, and then a tort is committed. Then vicarious liability as a principal or employer will happen, because here the relation changes from a parent or a guardian to a principal, agent, employer, servant, something like that. And when the father himself, by his own negligence, affords his child an opportunity to commit a tort, he is liable. Please read father/mother. I've written here father only, but please read it like that. So you yourself do some negligence and then it gives your child a right, a opportunity to commit a tort, you can be liable for it. You contributed to the negligence. Correct? The next category is independent and joint tortfeasors. Now, this is a long discussion. Independent and joint tortfeasors, what are the liability, how it will happen. But independent, as the word suggests, is sole entity, one person, and joint is two or more than two together. So let's understand what are independent and what are joint tortfeasors, and what is the kind of liability that they incur, and what is the right to sue or be sued in their cases. When two or more persons commit some tort against the same plaintiff, they may be either independent tortfeasors or joint tortfeasors. Now, independent tortfeasors, what are independent tortfeasors? When the act of two or more persons acting independently conquer to produce a single damage, they are known as independent tortfeasors. Now remember one thing, this entire discussion is with respect to one plaintiff. That is, one person getting the harm. There may be either multiple people acting independently or together. So independent tortfeasor is some people who independently act to produce a single damage. Okay, there is no concerted action on the part of independent tortfeasors. There is no concert or there is no meeting of minds when you do the wrong. There is mere similarity of design on their part, although they acted quite independently of one another. Now, what do you understand by similarity of design? We'll study it with the example, but always remember they did not act together in the same with the same intent. They acted separately. For example, two motorists driving negligently and coming from the opposite direction collide. A pedestrian is crushed between two cars. These motorists are independent tortfeasors. So, for example, if one person is standing, one person comes from here, one person comes from here. Both collide with that person. They have acted to cause the damage. Damage is single damage to that one person, but they did not intend together to do that act. So they have independently on their own, they did not know that this is going to happen, independently on their own caused that damage, and hence it is an independent wrong done by each of them. The damage may be single to one person, but the wrong independently was done. Okay, so this is why they are called independent tortfeasors. The liability of independent is not joint but several. Therefore, there were as many cause of actions as the number of tortfeasors. What do you mean by joint liability? That everybody is together liable? No. As many wrong persons have done, those many persons can be severally held liable. All of them will be held liable. When the persons are severally liable, an action against one of them is not a bar to action against other. So I can sue this person also, this person who gets harmed, this person also, somebody else also does a harm, all of them can be choose. If I have sued one does not mean the others cannot be sued. Okay, now this is independent. Understand, wrong is done against one person or one group as a particular and different wrongdoers. Joint tortfeasors. Two or more persons are said to be joint tortfeasors when the wrongful act which has resulted in a single damage was done by them not independent of one another but in furtherance of a common design. They were not independent, they had thought of it, designed it in some manner, and then they did it. So not independently but in concert, they all agreed to doing it. When two or more persons are engaged in a common pursuit and one of them in the course of and in furtherance of that commits a tort, both of them will be considered to be joint tortfeasors and liable as such. Two people decide to do something together and a tort is committed, they are joint tortfeasors. Together, conjointly, they've done the wrong. In independent tortfeasors, they have independently done the wrong to the same person, single harm happened. Now, there are certain persons who are also considered to be joint tortfeasors. They are considered to be treated as joint tortfeasors. Who are they? Principal and his agent. A principal and his agent. Okay. So if an agent does a wrongful act in the scope of his employment for his principal, the principal will be held liable along with the agent as a joint tortfeasor. If I am a principal and I tell my agent to do so and so thing and that results in a harm in the course of employment, in the scope of his employment, it should be within the scope of employment, they'll be considered to be joint tortfeasors. This we will also study in detail when we study the concept of vicarious liability. Now, in case of master and servant, a master and servant similarly, when the servant commits a tort in the course of employment of the master, both of them will be held liable as joint tortfeasors, joint liability. Okay, and partners in a partnership firm. For the wrongful act done by one partner in a firm in the course of performance of his duty as a partner, all other partners in the firm are liable along with the wrongdoer. So if one wrong partner does a tort, all other will be held liable. These will be studied again to understand the liability part under the concept of vicarious liability. So these are all considered to be joint. They are all doing it together because they are all doing it in the course of employment, in the course of doing acts which are authorized by one to the other. Now, the distinction between joint and tortfeasors and independent tortfeasors lies in the fact that in the former case, that is in the case of a joint tortfeasor, there is concurrence not only in the ultimate consequence, the ultimate result, but also in the mental concurrence in doing the act. So you decide together the ultimate result, the ultimate harm that happened, okay, there was concurrence, it happened together to the same person, but you mentally had also decided that you will jointly do so and so wrong. Okay. However, in the case of latter, that is in the case of independent tortfeasors, there is only concurrence in the ultimate result of the wrongful act done independently. So the act was done independently and you were then held liable because that resulted in the same category, similar damage. But in joint tortfeasors, you decide, premeditatedly decide. Okay. There's another category that is concurrent tortfeasors. Now, what is concurrent? That they who conquer, torts conquer or run together to produce same damage. So you produce the same damage in concurrent acts. They either they are either joint tortfeasors, briefly joint concurrent tortfeasors, where there is not only a concurrence in the chain of causation leading to the single damage, but also mental concurrence in some enterprise or several concurrent tortfeasors. That is independent tortfeasors, where the concurrence is exclusively in the realm of causation. Now, what do you understand by causation? Causation is the acts which lead to the ultimate result. Cause to the damage. So cause, what was the cause that led to the damage? The causation. This caused this. That link has to be established. Correct? If I am sitting here and if the roof falls, that was a result of somebody hammering the roof. That results in a tort committed by the person who hammered the roof to make the roof fall on me. So the causation link is clear. But if that person did not do it and I was sitting here and randomly the roof fell and somebody later on hammered it, there is no causation link which is established. So concurrent tortfeasors are what? They can be joint concurrent tortfeasors, that they together decide that one after the other we will do such and such acts to cause the damage. Or independently also what happens is I hit you, you fall on the road, somebody then puts the car over you. So this is concurrently torts happen, but independently. We did not concord, or we did not conquer to do that wrong. Okay. Then composite tortfeasors. In India, there is no such category of composite tortfeasors. But what do you understand by composite tortfeasors? When two or more persons are responsible for common damage, they are termed as composite tortfeasors. Okay. Now, why do we differentiate between joint tortfeasors and independent tortfeasors? I'll again repeat, independent tortfeasors, no mental element together, only acts done in concurrence which happen together to cause the same damage. In joint tortfeasors, you also have a mental construct or you have a common design to cause the damage. So, in case of joint tortfeasors, there was considered to be a single cause of action, and therefore, if a judgment had been obtained against one of the joint tortfeasors, the cause of action comes to an end. If the plaintiff is still unsatisfied, he could not bring an action against the remaining joint tortfeasors. So if we all concord together and do a tort, an action against one and a judgment against one is applicable to all, and you cannot bring action against 1, 2, 3, 4 separately. Why? Because they acted out of a similar mental design. However, in the case of independent tortfeasors, there was considered to be many causes of action as a number of independent tortfeasors. An action against one does not bar an action against the others. So an action against one will, so if there are independent tortfeasors, the number of independent tortfeasors, those number of actions you will have. Release of one joint tortfeasor releases all others unless there is an express stipulation to the contrary. However, this is not in the case of independent tortfeasors. In case of independent tortfeasors, release of one does not absolve liability of others. So the distinction is, in joint tortfeasors, one held liable, all other cause of action come to an end. In independent tortfeasors, this does not happen. In joint tortfeasors, one is released, all others are released until you have a contrary situation which is expressly stipulated here. In case of independent tortfeasors, however, if one is absolved of liability or release, others are not. Now, joint and several liability. Joint and several means together and each one also. Now, the liability of joint tortfeasors is joint and several. So you are jointly together liable, and severally each one is also liable. But when you bring an action against one and you take compensation, then the others are also released. The plaintiff has a choice to sue one of them, some of them, or all of them in an action. Each one of them can be made to pay the full amount of compensation. So you are jointly and severally liable. You cannot say no, sue everybody, then you will sue me. One can also be sued, all can be sued, some can be sued. The wrong done by the agent, both the principal and agent are jointly and severally liable. Even though the actual wrongdoer is the agent, if the the plaintiff so elects, he may sue the principal for the whole damage. It is on the plaintiff to decide who to sue. As against the aggrieved party, the principal cannot take the defense that the actual wrongdoer was the agent. Although, after making good the loss, the principal may hold the agent responsible to the extent of the agent's fault. So, you have to fight the case. Then you take money from him, that is a different case. But you will also be liable. The wrongful act done by the servant, the master is liable along with the servant. In case of a partnership firm also, the partners are guilty to the same extent. So joint and several means you are jointly liable. So you all are liable, and one of you can be sued, all of you can be sued, some of you can be sued. In independent tortfeasors, the parties whose actions are separate and unrelated, but together they cause the harm. The liability of each is dependent on the individual contribution to the harm. How much my action has harmed you, that extent of liability is based on. So if I only hit you, I will only be liable for hitting. If because of my hitting you fell and somebody run over you, I will not be liable for the running over. I will be liable for the hitting. The liability is several, independent, meaning that each tortfeasor is liable for the consequence of their wrongful act. They are liable for the wrongs of their act, not anything else, not somebody else's. So for example, in joint, they are liable for the entire wrong. Here you are liable to the extent of damage caused by you. If the harms caused by each joint tortfeasor can be clearly distinguished, the court apportions liability based on the contribution of each tortfeasor to the harm. So if they are distinct, the court will apportion the liability. The wrongly parked truck was hit by a bus driven rashly and negligently, and a person sitting in the truck sustained injury. Now there are two wrongs here: wrongly parked truck and being hit, by a bus which was driven negligently. The tribunal held that both the drivers are equally negligent. The damage was not a case of joint but separate actions independent of each other. They were independent actions. You did not park it correctly and somebody was driving rash and negligently. Okay. Now, release of joint tortfeasors. It has been well established rule of law since long that the release of one of the joint tortfeasors releases all other. Okay, so if you have held one liable, all other are held liable, and then you've released them. The release has to be distinguished from a mere covenant not to sue any one of them. I may agree not to sue one of them under any covenant, but the others are not released by an agreement with one. I agree with one that I will not sue you, but I will sue the rest. Okay. The release of one of the joint tortfeasors releases all other from their liability. But a mere covenant not to sue any one of them results in the discharge of only that particular wrongdoer from liability, the joint action against others still remaining alive. So that one person, one independent person with whom I have agreed that I will not sue you, only that person is released. The action against others remains. However, if there is no such covenant, and if I agree with one that I'm releasing, there is no liability, I will not keep suing one each one of them separately. Justice Salmon has said, the principle is quite plain. If that if there is a release of one joint tortfeasor, the cause of action against all other joint tortfeasor finishes. Okay, why? Because I have agreed there is the cause of action has ended. So if I release one, all of them have done. Why? Because they all acted with the same mental intent. They had jointly done that wrong. Okay. On the other hand, it is merely an agreement not to sue one of the several tortfeasors. The cause of action does not die, and other tortfeasors can properly be sued. So agreement not to sue one does not dissolve the liability. Now, in Shiv Sagar Lal versus Matadin, the plaintiff instituted a suit for malicious prosecution against several defendants, one of whom was the minor. The plaintiff filed an application in the court stating that there had been a settlement between him and the minor defendant and he had released the minor defendant. The court discharged the said defendant. The other defendant contended that the release of one tortfeasor amounted to the automatic release of others. So what happened in this case? One person sued a group of people for malicious prosecution. In that group, there was a minor also. So the plaintiff agreed and settled with the minor that I am not going to sue you, but the others wanted that since one of them is released, we should also be released. The court held that it has to be gathered from the intention of the parties whether there has been the release of the entire cause of action or merely a covenant not to sue one particular defendant. In this case, the court further said that there was settlement between the plaintiff and one of the tortfeasor, discharging him, and the suit proceeded against the others. That shows that the intention of the party to preserve the right against others, and therefore there being merely a covenant not to sue, did not amount to release of other joint tortfeasors. So a covenant not to sue one did not release the others. Now, what is release of joint tortfeasors? Again, we continue this. In some cases, it has, however, been held that in order that the release of one of the joint tortfeasors releases of one joint tortfeasors amounts to the release of all others, there has to be full satisfaction for the tort committed by the various defendants. Full satisfaction means you pay off. We know in torts the remedy is damages, so you fully satisfy with the damages with respect to the harm which has happened. If, for example, one of the several tortfeasors in the process of suit admits his liability as well as that of others and agrees to pay in satisfaction of his liability, that does not exonerate the other defendants who may be found liable for their acts complained of from their liability. Why? Because he is only paid to the extent of his liability. If he pays in full for everybody, then they are all released. Okay? But if he pays only for himself, he will be released. Khusro versus N.A. Guzder. This is a case where we will discuss about liability. The plaintiffs filed a suit against various defendants for defamation. Now, here a suit was filed for defamation. After the plaint had been filed and before the written settlements, one of them tendered an unconditional apology. So, you tendered an unconditional apology. The plaintiff accepted the apology and a request was made to the court that the claim against the defendant apologizing be disposed in terms of settlement of between the plaintiff and the defendant against that person who tendered the apology. A decree had been passed accordingly. In their written statement, the other defendants contended that the release of one joint tortfeasor extinguishes the plaintiff's right to sue and the remaining of them and claiming damages from them. So what here says is release of one joint tortfeasor releases the other. This is what is being held. It was held that this compromise could not be treated to be full satisfaction for the tort to have been committed by the defendants, and therefore the other joint tortfeasors were not released by the compromise. If he apologized for everybody and paid and it was accepted, then it could have been done. Now, what happens in case one of the tortfeasor pays, and how do you then take the remedy from the others? Now, what happens in the contribution? Contribution between joint tortfeasors. As in the just previous case, we had discussed that if one of them pays for all, it releases the others. Now, it says it has been noted above that liability of joint tortfeasors is joint and several. That is, they are jointly and severally liable. The plaintiff has therefore the right, if he so likes, to make only one joint tortfeasor to meet the whole of his claim. Now, what happens if one person pays whole of the claim? What happens? The question generally arises is that if one of the several tortfeasors has been made to pay not only for his own share but for others as well, how far can he claim responsibility with him to contribute for their share of responsibility? Can he claim for others? So yes, he can. There may be a situation where the joint tortfeasor who has been made to pay for the whole loss may not be guilty at all, and some other joint tortfeasors may be solely blamed for the wrongful act. In such cases, the joint tortfeasor may fully compensate that one who has actually paid the loss. That one joint tortfeasor must be indemnified for others. And in case of vicarious liability, if one who is not at fault has been made to pay for the wrong, he can claim indemnity for the others whose wrong he had otherwise been made answerable to. So you can claim indemnity. Okay. Now, this means that in cases of tortfeasors, you can claim liability, you can claim contribution. So if I pay the entire amount, I can ask everybody else to contribute. And if I pay for somebody else's wrong, I can claim the whole amount from them. So this is with respect to joint tortfeasors. In case of independent tortfeasors, the wrongs are independent liability. They are not required to contribute or indemnify. Okay, so there are independent tortfeasors and there are joint tortfeasors. In joint tortfeasors, the liability is joint and several. In independent tortfeasors, the liability is only independent, that is several. Between husband and wife. Now, under common law, initially when the wives were considered to be subordinate to husbands, there could be no action between husband and wife for the law of torts. It was considered that they could not sue for tort. Neither the wife could sue her husband nor the husband could sue the wife if the other spouse committed a tort. Now the husband and wife can sue each other as if they were unmarried. Now the law has evolved. Under common law, these things were there, but now they are not there. Now, persons having parental or quasi-parental authority, that is a teacher, a guardian, or somebody having control over you. So it says the law is that a parent, teacher, or any other person having lawful control or charge over a child or young person is allowed to administer punishment on him. So what is the requirement? That you are lawfully in charge of that person, having lawful authority over others. Parents are presumed to delegate their authority to the teacher when a child is sent to the school. So if you send your child to the school, you delegate your authority to the teacher, and such people have been allowed to administer punishment. Such an authority warrants the use of reasonable and moderate punishment only. And if there is an excessive use of force, the defendant may be liable for assault, battery, or imprisonment. So, a person having parental or quasi-parental authority may be sued for tort and can sue for tort if you exceed the power or exceed force. Only reasonable and moderate punishment can be allowed. Now, this is very fact specific. Moderate punishments are not liable for torts. Last category is persons having judicial and executive authority. See, there are some statutes also which absolve liability and which say that you will not be liable. Defense, we've already read statutory authority. However, these are some persons who are given certain exceptions to carry out their function. Protection to a judicial officer is granted for any act done or ordered to be done by him in the discharge of his judicial duty. The essence here being there has to be a discharge of your judicial duty. Only with respect to the discharge of your duty, if you've done any wrong, then you will be exonerated or not be liable to be suit. According to Halsbury's laws of England, the object of judicial privilege is not to protect malicious or corrupt judges. You are not doing this to protect the judges, but to protect the public from danger to which the administration of justice would be exposed if the person concerned therein were subject to inquiry as to malice or to litigation with those whom their decisions might offend. So, any person to whom your decision might offend, he might sue you if you are not given that protection. It is necessary that such persons should be permitted to administer the law not only independently and freely, but without favor, but also without fear. So, without having the fear of any prosecution against you, you have the right to sue and to take decisions. The protection is granted to judicial officer is absolute, provided that the act done by him is in the discharge of his judicial duties and was within his jurisdiction. So only those acts which are within your jurisdiction you are protected from. The protection is also granted if at the time of the act complained of he was acting out of jurisdiction, provided that in good faith he believed himself to have jurisdiction to do or order the act. So in good faith, any act which is done, you are protected. Whenever protection of the exercise of judicial power applies, it is so absolute that no allegation that the acts or words complained of were done or spoken malified, maliciously or corruptly or without reasonable or probable cause suffices to found an action. So it is an absolute protection to do what is lawfully required to be done in the exercise of your duties within jurisdiction. No such protection is granted if a magistrate is acting malified or outside his jurisdiction. So you will not be allowed to do it if you are acting outside your jurisdiction or under a malified intention. Now, executive officers or public servants also enjoy this protection, and the public servants are not liable for the acts done by them in exercise of their duty. So, for example, a police officer acting on a warrant which appears to be valid and is issued by a person having lawful power to issue, it has absolute protection for the acts done in the exercise of that warrant. So in the execution of a warrant, if a police officer does something, it may be a tort, but he will not be liable because he's doing it out of his authority. However, an officer arresting a wrong person or taking different goods or person than required is not excused. Similarly, there is no exception in executing the court order which has no jurisdiction. Acting under apparent authority, valid authority, is a defense, but the exception ceases if it is proved that the officer was acting maliciously to harm other persons. So here also the conditions are in the exercise of your duty, lawful authority, jurisdiction, and no ill intention in good faith. If this is met, the executive officers are also protected.